Your Honor, may it please the court, in case number 126533, State v. Jair Martin, the defendant is before the court today on an 8-count indictment. In counts 1 through 4, the defendant is charged with first-degree murder, punishable by life in prison without the possibility of parole or death. In counts 5 and 6, the defendant is charged with aggravated kidnapping, a Class B felony offense, punishable by a sentence between 8 years and 30 years in prison, and is subject to a mandatory service percentage of 100% pursuant to Tennessee Code Annotated 40-35-501.
Is that 185?
Yes, Your Honor.
Okay, that's 5 and 6.
Yes, Your Honor. In count 7, the defendant is charged with criminal impersonation, a Class B misdemeanor, subject to a maximum sentence of 6 months. In count 8, the defendant is charged with evading arrest, a Class A misdemeanor, subject to a maximum sentence of 11 months and 29 days. There is no agreed upon sentence in this case. The defendant is choosing to plead guilty as charged. He is further choosing to waive his right to a jury for the determination of his sentence, and he is electing for the court to determine the appropriate sentence in his case, including whether or not to impose the enhanced punishment sought by the state in counts 1 through 4 for sentences of life without the possibility of parole.
Do each of the first 4 counts charge premeditated first-degree murder, because they're felony murder counts?
No, there are alternate counts. 2 of them, there are 2 distinct victims.
Okay.
There are 2 counts of premeditated first-degree murder.
Is that 1 and 2?
Yes, Your Honor. And then there are 2 counts of felony murder. And it would be the state's position that upon conviction, count 3 would merge with count 1, and count 4 would merge into count 2.
All right. Is that the agreement, Ms. Lee?
Yes, Your Honor.
Let's go over this together, Mr. Martin. Mr. Martin, you were before the court today in docket number 126533. That is a multiple count indictment. Counts 1, 2, 3, and 4 each charge the offense of first-degree murder. Counts 1 and 2 charge premeditated first-degree murder. Counts 3 and 4 charge felony murder, or the murder committed, killing committed in the perpetration of a specified felony. Each of those 4 counts carry a potential sentence, a minimum sentence of life with the possibility of parole. In this state, that means that you must serve 51 calendar years before you are eligible to meet with the parole board. Do you understand?
Yes.
There are 2 other possible punishments for each of the first 4 counts. Life without the possibility of parole, meaning that if that punishment was decided upon for you, that you would never ever be eligible for parole, that you would have to serve the rest of your life in prison. Do you understand that?
Yes.
Do you have any questions about that?
No, sir.
A third possible punishment, which is not applicable to you because the state has not filed notice to seek the death penalty, would be death by lethal injection. That's not on the table here. So the 2 possible punishments for counts 1 through 4 are life with the possibility of parole, which means that you can't meet with parole board until you've done 51 calendar years within the custody of the Department of Corrections with credit for the time that you served within the Knox County Jail. Or life without the possibility of parole, which means that you are never eligible for parole, that you have to serve every single day that you have left on this earth in prison. You understand what those sentencing options are?
Yes.
You are also agreeing to plead guilty in counts 5 and 6 to aggravated kidnapping. That is what's known as a Class B felony in this state. Class B felonies carry a punishment range of between 8 and 30 years. Does the state, is he range 1? Is there any issue?
The state would concede he's a range 1 offender.
As a range 1 offender, that means your punishment exposure for each of these 2 counts is 8 to 12 years. What that means is that the minimum sentence which can be imposed on each of these 2 counts is 8 years, and it must be served at 100%. You would not be eligible for parole until you served at least 85% of whatever sentence with it between 8 and 12 years the court imposed. There is also the possibility that the court could order that there's certain statutory factors that the court has to consider, but there is the possibility that the court could order that these are to be served consecutively rather than concurrently at the same time with the first 4 counts. So in theory, you could be sentenced to a term of life or life without the possibility of parole, and the court could then impose a sentence, a consecutive sentence of between 8 and 12 years on each of these counts. Do you understand that?
Yes.
You are also agreeing to plead guilty in count 7 to criminal impersonation. That is a Class B misdemeanor with a maximum punishment of 6 months. You are also agreeing to plead guilty in count 8 to evading arrest, which is a Class A misdemeanor with a possible maximum punishment of 11 months and 29 days. Once again, those could be ordered to be served concurrently at the same time as the other counts or consecutively on top of the other counts. Do you understand that?
Yes.
Do you have any questions about what the possible sentencing exposure is on each of these counts?
No question.
And it's my understanding that you are agreeing to plead guilty without a recommendation as to sentencing. Is that correct? So in other words, you're agreeing to plead guilty to first-degree murder. Let's just lay this out here. The best possible day that you could have at sentencing is that you are convicted of first-degree murder. These counts are run concurrently or at the same time, and the court orders that you have the possibility of parole. But that still means you have to do 51 calendar years in custody, day for day, before you can meet with a parole. Do you understand that? So that's your best day of sentencing. Do you understand that? Do you have any questions about that?
No.
Have you discussed what your sentencing options are and what the possible sentences are that the court could impose with your attorney?
Yes, sir.
Are you confident in that you've had enough time to discuss those options with your lawyer?
Yes.
Is that the agreement that you've reached with the state to plead guilty in this case?
Yes.
And do you understand that it's also been announced that you're going to waive, you have the right, even if you plead guilty to first-degree murder, you have the right in this state to insist that a jury impose the possible punishments that exist for first-degree murder, that being life without the possibility of parole or life with the possibility of parole in your case. It is my understanding that you wish to waive the jury's consideration for sentencing in this case, and you want this court to make that determination. Is that correct?
That's correct.
Do you have any questions about that?
No, sir.
Do you understand that if you have a jury make the decision at sentencing that the state has to convince 12 people and that I have to approve that, so in essence they have to convince 13 people, if you waive that, then that they only have to convince me that these enhancement, the aggravating factors exist, which would merit a sentence of life without the possibility of parole. Do you understand that?
Yes.
And I want to make certain, Mr. Martin, that if at any point in time when we're having this discussion, when we go through all of these rights that we're getting ready to go through, when we go through your agreement that we're getting ready to go through, if you have any questions, I want you to stop me and ask me what that question is.
Okay.
Okay? If you need to speak with your attorney, I want you to stop me and say, I need to meet with my lawyer. Okay? Can you do that?
Okay.
All right. Do you have any questions at all about the sentencing considerations that we've just discussed?
No.
Do you have any questions at all about what the court just explained to you? And is it your decision, I'm asking that, I didn't ask that very well, did I? Is it your decision to let this court decide your punishment in this case?
Yes, sir.
Do you have any questions about that?
No.
You understand you have the right to have a jury make the determination of the appropriate sentence, even if you plead guilty to first-degree murder. You still have the right to have a jury make that sentencing determination. Do you understand?
Wait, let me speak to my lawyer.
Go ahead. Do you have any questions you want to ask the court about that?
No.
Do you understand you have that right to have the jury make that decision?
Yes.
And is it your decision that you wish to waive the jury and let this court make that determination?
Yes.
All right. The next thing that we're going to discuss, Mr. Martin, the court needs to make certain that you understand that no one can make you do this. Your decision to enter a plea of guilt today must be a decision that's made freely and voluntarily, and it must be your decision. Your attorney, Ms. Lee, cannot make you plead guilty. The state's attorneys cannot make you plead guilty. This court cannot make you plead guilty. Your decision to enter a plea of guilt today must be yours, and it must be yours alone. Do you understand that? And is this your decision to enter these pleas?
Yes, it is.
What is your full name, please?
J. Memorial Martin.
Ms. Lee, scoot that mic up a little bit closer for you.
J. Memorial Martin.
How old are you?
28 years old.
How far did you go in school? What is your educational background?
I went to grade 11.
Have you received a general equivalency diploma? Have you got a GED?
Yes.
So you can read and write without difficulty, is that correct?
Yes.
What is your home address?
441 Woodlawn Pike.
Woodlawn Pike in Knoxville?
Yes.
How long have you been in custody?
2 years.
Are you taking any medication prescribed to you while you're in the jail?
Yes, I am.
Does that medication affect your ability to understand these proceedings?
I don't think so.
Well, I need you to make me feel comfortable that you understand everything that's going on. You understand everything that we've covered up to this point.
Yes, sir.
Do you have any questions?
No.
Are you under the influence of any medication that you're taking in the jail?
No.
All right. So once again, do you understand everything that's happened so far?
I have.
Is there anything you wish to talk to the court about or your lawyer about anything that's happened so far?
No.
Has anyone forced you, pressured you, or threatened you to make you plead guilty?
No.
Has anyone promised you anything other than your plea agreement in exchange for your plea guilty?
No.
In order for us to be successful in this hearing, Mr. Martin, you're going to be called upon to waive a number of rights. This court does not have the power nor the authority to accept your plea of guilt, approve your plea agreement, nor to enter judgment conviction against you unless you give me that power. And the way that you do that is by waiving a number of rights that you have. I'm holding a document titled Waiver of Trial by Jury and Request for Acceptance of Plea of Guilty that has your name at the top of it. Have you read this document? That's the plea. That's the plea form.
Oh, yes.
Is this your signature that appears on the last page of this document?
Yes, sir.
Have you discussed the contents of this document with Ms. Lee?
Yes.
Do you understand the constitutional rights that are explained within this document?
I do.
Do you have any question about any of those rights?
No, I don't.
In addition to the fact that you've signed a written waiver of certain rights, the law requires that this court advise you in open court and that we have a discussion on the record about a number of rights that you have. First among the rights we're going to be discussing is your right to a trial by jury. You are presumed innocent. You have no burden of proof anything in this case. The burden of proving your case on each and every one of these counts rests upon the state of Tennessee, and that burden never leaves the state. If your case went to trial, a jury of 12 people would be impaneled who knew nothing about the facts of your case and who could be fair and impartial. The burden would be on the state to convince all 12 jurors beyond a reasonable doubt to moral certainty that you had committed some crime that they accused you of committing. All of that would have to take place before you could be convicted of any criminal offense. However, if you waive your right to a trial by jury, at that point in time, that gives this court the power and the authority not only to accept your plea, but also to enter judgment conviction against you and to sentence you. Do you understand that you have the right to a trial by jury on each and every one of these counts?
Yes, sir.
Do you understand the consequences of waiving those rights?
Yes.
And do you waive your right to a trial by jury on each of these 8 counts?
Yes.
You have other rights, which includes the right of confrontation and the right to compulsory process. The right of confrontation means that any witness the state wished to call against you would be subjected to cross-examination by your attorney. The right of compulsory process means that any witness who had evidence favorable to your case could be compelled to appear in this courtroom and offer testimony on your behalf. Do you understand what each of those rights mean?
Yes.
Do you want me to explain either of them further?
No, sir.
Do you understand that by entering a plea of guilt that you're waiving each of those 2 rights?
Yes, I do.
You have the right to have an attorney with you through every stage of these proceedings. if you couldn't afford to hire your own attorney, one would be appointed to represent you at no cost to you. You're fortunate to be represented by a very good lawyer. Are you satisfied with the services provided by Ms. Lee?
Yes, I am.
You have the right to remain silent. What that means is that no one can force you nor compel you to say anything which might incriminate you in this case. If your case went to trial, you would have the right to testify if that was your decision. However, because you are the accused person in this case, you have the right to remain silent. And if you chose to remain silent and not to offer testimony, no one could comment on your silence, no one could attempt to call you as a witness, and this court would instruct the jury that the jury could consider your silence for no purpose because you are presumed innocent and have the burden to prove anything. Do you understand that you have the right to remain silent?
Yes.
You understand that in a moment this court's going to ask you whether or not you're guilty in each of these 8 counts. You understand that's getting ready to happen.
Okay.
As to these proceedings only, do you waive your right to remain silent? Do you have any questions about that? And finally, Mr. Martin, had your case gone to trial and been convicted of a crime, you would have a right to appeal that conviction to a 3-judge panel who would review the record created within this court. If that court found after reviewing the record that some error had taken place, that court could reverse the conviction and send the case back to this court for a new trial. If that court found after reviewing the record that there was insufficient evidence in the record to support a conviction or convictions, that court could reverse and dismiss the case against you entirely. However, what is taking place in the hearing that we're conducting at this moment is a final, non-appealable hearing. You reserve the right to appeal whatever sentence this court imposes if you're dissatisfied with that sentence, but as to your guilt or innocence, you understand that this is a final, non-appealable hearing. In other words, this is it. You understand that?
Okay.
I need you to say, yes, I understand.
Yes.
And do you understand?
I do.
The court has observed, Mr. Martin and Ms. Lee, for the record, you were, based on your examination and that of your experts, you believe that Mr. Martin is competent to enter a plea of guilt. Is that correct?
Yes, Your Honor.
Mr. Martin, in document 126533, as to the first count, alleging first-degree premeditated murder, how do you plead, sir?
Guilty.
As to the second count, alleging premeditated first-degree murder, how do you plead?
Guilty.
As to the third count, alleging felony murder, how do you plead?
Guilty.
As to the fourth count, alleging felony murder, how do you plead?
Guilty.
As to counts 5 and 6, each of which allege a Class B felony of aggravated kidnapping, how do you plead?
Guilty.
As to the seventh count, alleging criminal impersonation, a Class B misdemeanor, how do you plead?
Guilty.
And as to the eighth count, alleging evading arrest, a Class A misdemeanor, how do you plead?
Guilty.
The court will further find that Mr. Martin is here of his own free will and volition, prepared and in fact entering a plea based on the agreement discussed between the parties, and that he has knowingly and voluntarily waived the rights that have been discussed in the court and spread upon the rights waiver. General, if you would read the counsel being.
Does the defendant waive formal reading?
Yes, sir.
Okay. Mr. Jair Martin, this is to inform you that the grand jurors for the state of Tennessee, upon their oaths, present that you, on or about the 13th day of May 2023 in Knox County, Tennessee, and before the finding of this indictment, did unlawfully, intentionally, and with premeditation kill Madison Johnson in violation of TCA 3913-202 and against the peace and dignity of the state of Tennessee. In the second count, the grand jurors for the state of Tennessee, upon their oaths, present that you, on or about the 13th day of May 2023 in Knox County, Tennessee, and before the finding of this indictment, did unlawfully, intentionally, and with premeditation kill Heidi Johnson in violation of TCA 3913-202 and against the peace and dignity of the state of Tennessee. In the third count, the grand jurors for the state of Tennessee, upon their oaths, present that you, on or about the 13th day of May 2023 in Knox County, Tennessee, and before the finding of this indictment, did unlawfully kill Madison Johnson during the perpetration of or attempt to perpetrate the crime of kidnapping in violation of Tennessee Code annotated 3913-202 and against the peace and dignity of the state of Tennessee. In the fourth count, the grand jurors for the state of Tennessee, upon their oaths, present that you, on or about the 13th day of May 2023 in Knox County, Tennessee, and before the finding of this indictment, did unlawfully kill Heidi Johnson during the perpetration of or attempt to perpetrate the crime of kidnapping in violation of Tennessee Code annotated 3913-202 and against the peace and dignity of the state of Tennessee. In the fifth count, the grand jurors for the state of Tennessee, upon their oaths, present that you, on or about the 13th day of May 2023 in Knox County, Tennessee, and before the finding of this indictment, did unlawfully and knowingly remove or confine the victim, Madison Johnson, so as to interfere substantially with the victim's liberty, while you were in possession of or threatened to use a deadly weapon in violation of TCA 3913-304 and against the peace and dignity of the state of Tennessee. In the sixth count, the grand jurors for the state of Tennessee, upon their oaths, present that you, on or about the 13th day of May 2023, in Knox County, Tennessee, and before the finding of this indictment, did unlawfully and knowingly remove or confine the victim, Heidi Johnson, so as to interfere substantially with the victim's liberty, while you were in possession of or threatened to use a deadly weapon, in violation of TCA 3913-304 and against the peace and dignity of the state of Tennessee. In the seventh count, the grand jurors for the state of Tennessee, upon their oaths, present that you, on or about the 13th day of May 2023, in Knox County, Tennessee, and before the finding of this indictment, did unlawfully, with intent to defraud Sarah Rodriguez, an agent of the Knoxville Police Department, assume a false identity, to wit, that you did identify yourself to be Demario Martin when stopped by Sarah Rodriguez in violation of TCA 3916-301 and against the peace and dignity of the state of Tennessee. In the eighth count, the grand jurors for the state of Tennessee, upon their oaths, present that you, on or about the 18th day of May 2023, in Knox County, Tennessee, and before the finding of this indictment, did unlawfully and intentionally conceal himself or flee by any means of locomotion from a person known to you to be a law enforcement officer, and that you knew the law enforcement officer was attempting to arrest you in violation of 3916-603 and against the peace and dignity of the state of Tennessee.
Ms. Lee, as to each of these 8 counts, how does Mr. Martin vote?
Guilty, Your Honor.
Your Honor, the state anticipates, had these cases gone to trial, the witnesses listed would testify that on May 13th of 2023, Madison Johnson and Heidi Johnson had stayed overnight at the home of Jair Martin, located at 441 Woodlawn Pike. In the morning hours of May 13th, Jair Martin was involved in a conversation with Madison Johnson that turned into an argument. Jair Martin was commonly known to go by the nickname of Max. During the argument, Jair Martin became armed with a Ruger 5.7 pistol, and at one point he blocked the front door with a wooden blockade. During the argument, 2 other occupants of the home, David Lively and Courtney Lynch, escaped the home prior to any escalation of physical violence. During the course of this argument, Madison Johnson called her mother, Carrie Johnson, from inside the home trying to get assistance. She expressed that she wasn't being allowed to leave and that she was in fear of Jair Martin. Ms. Carrie Johnson called 911 for assistance to the property while she remained on the line with her daughter. At the time, there were also 3 exterior surveillance cameras at the property that were making visual recordings of the outside of the property, but were also capturing audio recordings of some of the events that were occurring inside the home. In the recordings, Madison Johnson can be heard saying, "Max, open the door," multiple times, as well as "let me out of the house." And she can be heard telling him that her mom was going to call the police if he did not stop. Madison can be heard telling Mr. Martin, "We can talk," or "I told you we can talk." Jair Martin is heard telling Madison that he will kill himself before he goes to jail. Jair Martin is also heard saying, "I'm okay with being friends and all that. That's why I want to talk to you about." He is then heard saying, "Madison, don't leave like that." Mr. Martin is heard pleading, "Please talk to me." And then he can be heard saying, "You're going to get murdered." Madison can be heard yelling, "Don't put a gun to my head." Martin can be heard saying again, "I'm going to kill you." And then a single gunshot can be heard fired. A female voice, who is believed to be Heidi Johnson at that moment, can be heard screaming, "Oh my God," after the first gunshot was fired. Then another series of shots are heard with a total of 10 captured on audio. The last shot can be heard on video at 9 a.m. At 9:05 a.m., Officer Sarah Rodriguez, who was responding to the 911 call, encountered David Lively and Courtney Lynch about a quarter mile down the road as they were escaping the home. They reported that they had left because an argument was escalating in the home and that Max would not let Madison leave. Courtney reported hearing shots fired very shortly after she left. At 9:08 a.m., just a little further up the road on Woodlawn Pike, Officer Rodriguez actually encountered Jair Martin walking in the roadway wearing black pants and a red sweatshirt. She stopped Mr. Martin for a brief interview. During the course of the discussion, Jair Martin identified himself to be DeMario and told Officer Rodriguez he lived at 437 Woodlawn Pike and that he had heard gunshots being fired at 441. He told Officer Rodriguez he did not know who lived at 441 Woodlawn Pike and appeared very calm in his interactions with her. At the time, Officer Rodriguez had received information over dispatch that the suspect was an African-American male, but that he was believed to be wearing a white shirt, and the reporter of the call believed that he had re-entered the home. Since the suspect was believed to still be in the home at the time and believed to be wearing a different color shirt, and because Officer Rodriguez did not know his true identity or his residency at 441 Woodlawn Pike, Mr. Martin was allowed to then continue walking away from the scene at that time. Multiple units from the Knoxville Police Department then arrived on scene, including a special operations force. The special operations team attempted negotiations from outside the home, believing that the suspect may be inside, armed and dangerous, but they did not get any response from anyone inside. Officers were ultimately able to see one of the victims, Madison Johnson, through a window, and they could tell that she was in the floorway incapacitated. At that time, they had to force entry into the home, which took, breaking through the front door that had been blockaded. Once they entered, they initially found Madison Johnson deceased in the floor in a common living area of the home, just a few feet away from the front door. She had obvious gunshot wounds as well as slash wounds, and also a large turkey fork was lodged in the side of her head. Madison had a backpack around her arm and shoulder, indicative of her intent to leave the property. Her cell phone was located directly underneath her body. Heidi Johnson was then found in the back main hallway of the home, where she had several apparent gunshot wounds in her chest and in her thigh. She also had a backpack around her shoulder and arm, indicative of an intent to try to leave the property. Multiple spent shell casings were located throughout the home, and a Ruger 5.7 was found abandoned in a bush on the front side of the home. A butcher knife with blood was located in very close proximity to Madison Johnson's body, in addition to the fork that was left lodged inside of her head. Firearms analysis was performed by Lieutenant Brian Dalton with the Knoxville Police Department on the spent shell casings that were found throughout the home, and it was determined that those shell casings had been fired by the Ruger 5.7 that was abandoned just outside of the home's exterior. Dr. Lauren Havrilla performed autopsies on both Madison and Heidi Johnson. Madison Johnson was 21 years old at the time of her death. Dr. Havrilla determined that Madison Johnson suffered 3 perforating gunshot wounds, one to the head, one to the torso, and one to the left upper arm, as well as at least 31 distinct sharp force instrument wounds, both puncture wounds and slash wounds to her head, neck, and upper torso. One of the stab wounds punctured her jugular vein. The cause of death was determined to be the combination of multiple gunshot wounds and sharp force injuries, and the manner of death was determined to be homicide. Heidi Johnson was 20 years old at the time of her death. Upon her autopsy, Dr. Havrilla found that Heidi Johnson suffered at least 5 distinct gunshot wounds and possibly 7, depending on whether or not 2 of the entry wounds were re-entry wounds. She had a gunshot wound to her head, to her right upper arm and torso, one that entered her right mid-back, one that entered her posterior left shoulder, one that entered her right forearm, and one that entered her left breast. Her cause of death was determined to be multiple gunshot wounds, and her manner of death was determined to be homicide. After the homicides occurred, Jair Martin was identified that same day to be the suspect. A multi-party search for Mr. Martin ensued by the Knoxville Police Department. On May 18th of 2023, Jessica Willis contacted the Knoxville Police Department to report that Jair Martin had come to her home and was hiding out there. Ms. Willis was interviewed, and during the course of her interview, she reported knowing both of the victims to be sweet young women. She told investigators that she asked Mr. Martin why he had killed them, and he told her that he killed them because they had kept stealing drugs from him. Officers with the Knoxville Police Department went to Ms. Willis's apartment to arrest Mr. Martin. Multiple officers surrounded the apartment and knocked on the doors and windows. Megaphones were used to command Mr. Martin to come out and surrender himself. A K-9 unit was utilized to enter the apartment when Mr. Martin wouldn't respond to the commands to surrender. The K-9 was able to locate Mr. Martin hiding in a bedroom closet. Mr. Martin was taken into custody at that time. At that time, he did appear to be having complications from consuming drugs, including vomiting. Narcan was used, and he was taken to the hospital for medical treatment. Once released from the hospital, he was taken to KPD for an interview with Detective A.J. Luffler and Chaz Terry. Over the course of a 2-day interview, Mr. Martin told investigators that he was at the home and was in an argument with Madison Johnson. He said Heidi had become involved in the argument and that both women were preparing to leave, and that he was angry that they were trying to leave because he believed Heidi owed him money. He also reported that he was angry that Madison was bringing police attention to the home. At one point during the argument, he said he heard an ambulance drive by and that it made him jittery, believing that police might arrive at the home at any minute. He mentioned that he didn't want police interaction because he had illegal stuff on him that day. He did remember putting a gun to his own head. He remembered Madison trying to get out of the front door, and he remembered getting into a tussle with her. And he remembered that Heidi was right behind them as he tussled with Madison. He then told investigators that at some point he snapped and went into a blackout state where he has no idea what happened next or what he may have done. He admitted that he came out of his blackout state to discover that both Heidi and Madison Johnson were dead and that he still had a gun in his hand. He admitted that at that point he gathered his drugs and left the home through a window. Mr. Martin did at times give some inconsistent accounts of what happened, at one point claiming that it was another individual named Joe who was there that had killed them, and he then later recanted that assertion. And all of these events did occur in Knox County, Tennessee.
Ms. Lee, is there anything you wish to add to the stipulated proof in this record?
No, Your Honor.
Court will accept Mr. Martin's pleas as having been freely and voluntarily given with a sufficient factual basis in support of pleas. The court will reserve further entry of judgment in this case. Counts 1 through 4, this matter will be set for further hearing on the 16th of June, and I will conduct a sentencing hearing. Prepared a written waiver of jury for Mr. Martin's signature on counts 1 through 4 for sentencing. Court will conduct further sentencing hearing on counts 1 through 4 on the 16th of June. The other counts will remain on their status, and the court will conduct a subsequent sentencing hearing on those counts after the receipt of further proof. Anything else we need to take up today?
Judge, do you want that written waiver completed today or on the
The
16th?
16th will be fine.
Okay.
16th.
And what time do you expect for us to start on the 16th?
I'll have, since next week is judicial conference, I'm confident there will be a number of matters that I'll have to take up that morning. Let's plan on starting around 10:30 that morning. We'll work for a couple hours. If we need to work that afternoon, we will as well.
Okay, thank you.
All right, Mr. Martin, I will see you back on the 16th, and we will conduct a sentencing hearing on the homicide counts at that time.
Thank you.
Enter an order of vote meeting. Mr. Cody Martin,